I don't know, if you went in his face and shot Ailey, if that
Right.
was a crime, like, you prevent investigation.
So when it comes to life and legal, how should we reconcile these situations while maintaining faith in the legal process?
But what I can say is that the general purpose of the pardon, at least the perception of it, is a cure, a fix. You know, I don't know, and maybe it is out there, but they're using this as a shield, at least the moral high ground that the Democratic Party believe they can stand on in the context of respect for the rule of law got sort of blown out the window by all of this. At least.
So now let's apply this to an entrepreneur listening to this. What remedies exist for me if I feel like I'm being misled by someone who never intended to follow through? Welcome back to Life, Legal, and the Headlines, everybody. Look, this is a show where we dissect today's biggest legal stories and the lessons they offer for our own lives. I'm your host, Chris Farrell, and today's episode, we're focused on broken promises and broken deals. And, I'm here with Gavin Elliott, legal expert. He's been a part of tons of these cases, and so we're going to unpack a lot of this today. So, Gavin, first off, what's up, man? How are you?
I'm doing well, Chris. Good to see you again. As always, looking forward to having a conversation.
Yeah, man. Yeah. So recently in the headlines, we have seen a lot. And one thing in particular that has shocked the nation, maybe I'll say has just been something that some people didn't think would happen, but I think a lot of people are like, oh, I'm not surprised, is the pardon that Joe Biden has now pardoned his son, Hunter Biden. So unpack that for me a little bit for those who aren't really sure what that means and what's going on.
All right. Well, I actually, in preparation for our conversation today, I pulled up a copy of the precise language of the pardon. And I just want to read a little bit of that to give some context to people who are listening. It starts with executive grant of clemency, Joseph R. Biden Jr., President of the United States of America. And it goes on, be it known that this day, Joseph R. Biden Jr., President of the United States, pursuant to my powers under Article 2, Section 2, Clause 1 of the Constitution, have granted unto Robert Hunter Biden a full and unconditional pardon. Sounds pretty standard so far. Here's where it gets really interesting. For those offenses against the United States, which he has committed or may have committed, get back to that later, or
Right.
taken part in during the period from January 1st, 2014 through December 1, 2024. So there is a lot there, to be honest, Chris, like a lot there. And it is unusual that traditionally when anyone thinks of a pardon, you think of someone's in jail for something, they'll get pardoned, they'll get out.
Sure.
You don't think, or someone's being prosecuted for something and the prosecution stops. You don't think of a pardon applying to anything he might have done, anything he took part in. Like, you don't think of it in the context of unidentified crimes that may or may not have taken place. But that's the first point. And I mean, the time frame, we're talking January 1st, 2010. I don't think that time frame is coincidental. People listening can check this out themselves. Hunter Biden started working at Burisma on the board of directors. Burisma, I believe, was a Ukrainian oil company, certainly a Ukrainian company. He was very well compensated. And without touching on the legitimacy of that here, right now, in 2014. So that year of 2014 just coincidentally lines up with the exact time that Hunter Biden joined Burisma. So there really is a lot there.
Do you think that's why this pardon is striking such a nerve for the public?
I think the nature of it does. Yes. I think and from the commentators I've read, a pardon of this nature just hasn't been done before. That's not saying people don't get pardoned. They get pardoned all the time. Oftentimes when presidents are leaving office, they'll issue a slew of pardons. But it's usually for things that people have been convicted of, charged with, and things of that nature. Like, may have committed. It's sort of weird to pardon someone for something they may have done,
My understanding of pardons, Gavin, was that People were in jail, had served their time, and it was like, okay, hey, you're good. I'm going to use my presidential power to now pardon you and take you away from the crimes. I didn't even know pardon was prior to going into prison.
Well, and I think your understanding is most people, and I don't profess to be a constitutional scholar on this particular issue, but what I can say is that the general purpose of the pardon, at least the perception of it, is a cure, a fix. You know, I don't know, and maybe it is out there, but they're using this as a shield. And there's a big difference between fixing something that happened and shielding something from every possibility that may be related to whether he committed the crime or not. You know, and it's almost like it's designed to prevent investigation into his son whatsoever. Like
Right.
there was the pardon purpose with the crimes he pled guilty to, which were tax evasion and the lying that he wasn't addicted to drugs when he had a firearm. But you know what? You know, some could argue that the firearm charge was even though legitimate, very rarely litigated, but the tax charge, people get charged with that stuff all the time. But regardless, if Biden had just done what we all thought a pardon was, perhaps it wouldn't be as bad. But by almost creating like a shield from a quasi shield from law enforcement or anyone else investigating him, because they can never get a conviction because he's been completely pardoned for, I don't know, if he went into space and shot aliens, if that was a crime, like you prevent investigation. It's not just about pardoning him. It's about preventing investigation, in my opinion.
Right. Well, so are there any legal laws in place, to your knowledge, that would make sure that there was no blurring of the lines between family loyalty and actual like public responsibility?
I don't believe they're effective. I guess to the extent they do exist, they do not appear to be effective. You have to remember there was, in the field that Hunter Biden was brought on board as a board of directors and very well compensated, I believe in the millions, he had no prior skill set or knowledge in that particular field. And then to top that off, at around maybe a little bit off timing wise, but there was that famous speech, and I'm paraphrasing a little bit, where Biden said, you know what, I went to the Ukraine and I told them if they didn't, and I think he was talking about removing a prosecutor who was investigating corruption, but whatever the event was, if the Ukraine didn't do this, they're not going to get the $1 billion. And by God, they did it. So, I mean, you have someone's son on the head of a company in the Ukraine, and you're going in and telling the Ukrainian government, yeah, you need to fire this guy who's investigating corruption. Like, or alternatively, even if that's not the aspect, you're holding money over their head for some reason because you want them to do a particular thing. I mean, it's super suspicious.
Well, so we talk about life, legal, and the headlines. So when it comes to life and legal, how should we reconcile these situations while maintaining faith in the legal process?
That's a really good question, actually, because they're, you know, and Jon Stewart from The Daily Show, he was talking about how he's brilliant, by the way. I don't always agree with him, but he's absolutely brilliant.
Yeah.
And he was talking about how, like, well, you know, we're the Democratic Party and we're the party of appreciation for the rule of law. And then the clip comes in, Hunter Biden pardon. He's like, God damn it, whatever.
Right.
He was pissed off about it because, like, at least the moral high ground that the Democratic Party believed they could stand on in the context of respect for the rule of law got sort of blown out the window by all of this. At least that's what people are saying. And I tend to agree with it. The other bad thing about it is, and I would have handled this differently myself. I mean, I was born in England, so I can never be president. But if my son was facing criminal charges and someone asked me, if your son is convicted, will you pardon them? I wouldn't say no, which is what Joe Biden said. I would say, listen, I'm not going to prejudge sort of the answer you get from Supreme Court justices when I will not testify about a specific case, or, I will not predetermine a case. Just say, I'm not going to prejudge a situation. I have to see how it would unfold. And after that, in consult with, advisors, I would make the proper determination at that point in time. Well, why won't you at this time make a full commitment to that? Because I don't know all the facts yet and can't know all the facts until the situation has played out. This may be a question that never needs to be answered because he may not get convicted.
Yeah.
So why am I going to tell you what I'm going to do about something that may never happen? Well, why don't you ask me what happens if dinosaurs come back to life? Come on.
Sure.
Don't waste my time.
No, man, that's good. And so what's interesting about this is you mentioned previously, like, I don't think that law is effective. I asked you about essentially, like, why should we trust the legal process? And now we're starting to talk about promises made with no intent to follow through. And in this particular case, there's literally nothing we can do about it except for make fun of his decision and see, like, all right, well, you showed your true colors. You were obviously just trying to put on a show for election purposes. But now that you lost, you have nothing to lose because you're out anyway. So now let's apply this to an entrepreneur listening to this or watching this. And they're like, hey, Gavin, I'd love to know. People come to me all the time with deals or contracts or verbal agreements or whatever. What remedies exist for me if I feel like I'm being misled by someone who never intended to follow through?
And that is a tough one because, the idea of a well-drafted contract or agreement is that everyone's expectations are well-defined and you know what's going to happen. When people are acting with fraudulent intent, doesn't matter what you write down. I used to say this in the context very early on, like more than 20 years ago, in the beginning of my practice. And I still say it now, but it was more relevant then. They're like, listen, a domestic violence injunction says that person can not come within a certain amount of feet with you, not interact with you. But honestly, like, there's no piece of paper in the world that's going to stop crazy or evil. Crazy or evil doesn't care about contracts and agreements and things like that. So the purpose of a well-drafted contract is to try to mitigate the damages that can arise in those situations with quick remedy, etc. But really, evil and crazy are really hard to stop with a few pages of paper.
No, man, that's totally fair. Now, let's work a step backwards, though. What red flags should I be looking for, or how can I protect myself from getting taken advantage of someone who never had intent to follow through?
This reminds me a little bit of a situation that I had with a client of mine. And the easiest way to prevent disputes after the fact is to be as detailed as possible in the language of the agreement. So instead of saying, we'll return all this or do all that, you list and itemize the individualized elements so there can be no argument that this is not what I meant, Well, when I said give everything back, I just meant it from this time frame. Or when I say I would do this task, I meant it in this limited context, You want to remove the ability for someone to alter the intent of the agreement, not even ambiguity, but manufactured ambiguity.
Yeah. Well, okay. Let me give you an odd example. Okay. So let's say someone came to you and they're like, Gavin, you have a firm with multiple locations in various different places and it seems like you're successful. I love your brand. I love everything about it. I'd love to white label what you have going on, and I will essentially take your brand and do the same thing and then pay you a commission, right? And then I will take on clients for you, and then you want to do any work, I'll just use your brand and here you go. Here's some money. But it sounds good to you because you're like, well, I don't have to do any extra work. I already built the brand. Awesome. But they never had intent to follow through. Well, let me start here. How do you know that they have intent to follow through? What types of things would you be looking at in that scenario to vet the person, if you will?
And again, it goes to detail, not even in writing, but in the conversation.
I know I'm throwing you a curveball.
No, you are. And
I just want you to think like, here's a situation. Someone comes, they say, hey, Gavin, love your brand. This is what I want to do. What are your red flags? Get me in your brain to help me make a good decision on whether this is good or not.
Well, let's put it this way. One of the problems that can exist in the context of negotiations, and other attorneys may disagree with me on this, and there are some circumstances where they would be right, but you have the attorneys who, even though they may possess comprehensive factual knowledge, they're not intimately familiar with the details. So one of the ways you can help mitigate that is to actually have like negotiations involving the clients and the attorney, not just one or the other. I'll be candid. Most of the time, my clients just want me to handle it myself and not involve them in it. But these clients, they can sit down, they can talk with each other, they can say, all right, so we're saying we'll do this. So that orally, this covers this. So you get oral confirmation of it. You obviously memorialize the conversation in writing later, later, and then you memorialize it in an agreement. But you have these things, these intimate details, and also the intent of the parties, at least the apparent intent, clearly enunciated as between, clearly discussed as between the parties. So I think that's a useful step. And also, listen, when I remember I was negotiating this one deal, and I was not an expert in the field, and there was someone there who was, but what I was doing was reading body language the whole time the negotiations were going on. So, like, I mean, I guess sociopaths don't have that as many ticks, but if you're dealing with like regular people, they will have tails when they're saying something that isn't necessarily in agreement with what they actually intend to do.
Yeah.
You know, so like in person, clients and attorneys discussing things can be very helpful.
So, because I know this is valuable for the listener to get further into depth on the details within this, let's say you're representing me and that person comes to me and they say, Chris, I love that you're helping people with this, right? Great brand. I want to now sell the same thing, etc. And I say, Gavin, handle it. I don't have time. But this is interesting to me. Where do you start? What does that look like?
Well, the first thing is a full and detailed, as I want as much client involvement as possible.
Okay.
Honestly, contrary to what as much client contact may seem to me, it actually saves the client time because I'm not questioning what their intent is. I have no ambiguity with my own client. So it's very important out of the gate to define the expectations of the client. And they ultimately define those, and they may be modified based upon what's realistic as well. So you as counsel advises that. Based upon that information, I can then move forward and draft up the agreement. Of course, depending upon, there is due diligence, and that's obviously very important. But I'm putting due diligence aside. Due diligence will reveal when someone is lying about something they can't do. So what I mean by that is if someone's saying, I'll help you build this particular product, and you conduct research and they have neither the academic, professional, or any other background that would enable them to do this, and you find out their references are bogus, well, you know they're lying.
Yes.
But those are the lies that due diligence can reveal. The lies inside of someone's head are a little bit more difficult to ascertain, to figure out. So, I mean, that's where the in-person meetings, the reading of the body language, much as I have done when, picking a jury to see if people are, no one loves, I mean, maybe some people love jury duty, but most people don't love jury duty. I mean, just a very brief aside, it reminds me of this. I got called for jury duty once. The judge was like, does anyone know any of the people here? And I'm like, yes, Your Honor. I've argued a trial. I've argued trials in front of you. I've been co-counsel with defense counsel, and I've argued cases against plaintiff counsel before. So I'm like, yeah, I know people. But anyway, getting back to the topic of for the internal stuff, it is difficult. It is in specificity, both orally and ultimately memorialized, is the best bet to limit what happens. The other thing that's possible is, having clauses in the contract that bring in third parties that bring about the completion of the transaction upon satisfaction of all conditions. A standard escrow agreements don't just have to be about money. There are preconditions, for example, that are required to be satisfied. So that kind of language can also protect you against someone who's intended to lie, because, and perhaps I should have mentioned this early, you try to remove their ability of their lie to impact you. So by bringing in an independent third party to ultimately close the transaction, if you would, you prevent the lies from being able to impact you as much.
Okay, so what do you mean by that? Give me an example.
Say in the context of a sale of a house, right? There's two parties who want to have a deposit released. And in having the deposit released, they say, I will forgive all debt and I'll get my deposit back. And then you have those documents in place. So you have that agreement. A third party, first of all, you delineate with specificity, but a third party can ensure that there is compliant. So, for example, if there were outstanding debts that he had as to him, maybe he does a 1099-C, which is a form with the IRS, which is forgiveness of debt, or something like that. I mean, your clients may be uncomfortable with having to take on the tax obligation of a 1099-C, but at least he knows that that debt is gone. Specifically, and again, having the release that's executed at the time of closing specifically detail everything that's being forgiven. because there are the scenarios where there are lies that can be prevented. There are the scenarios where they just can't. I mean, more often than not, people deliver the goods before getting paid, for example. And sometimes people just had no intention to pay. They just wanted the good. In your white label scenario, that's way more complicated because that's an ongoing relationship. So in that context, there may be things you would want, such as joint access to accounts, reporting. Joint access to accounts is going to be a difficult one to run by them, to be honest. But certainly access for purposes of viewing the transactions and things of that nature. And also you have to be careful with white labeling, because if you let someone run your brand in a way that's inconsistent with the trademark, you could lose your trademark. So you have to be careful about that as well. You do have obligations to protect your trademark.
Yeah. So let's say I have someone who wants to white label my brand.
Yeah.
And they want to represent my brand, sell my brand, all the things. They're saying, hey, man, you already have it all built. You've done a great job. It's very clear and concise. I love what you're offering. I'll sell it for you, and then I'll cut you commission. How would you represent me if I didn't have time to deal with it? We'd had talks that kind of make sense and say, hey, Gavin, take care of this for me. See if this is legit. Could be a good deal, but I got to run my company.
Okay. All right. The answer is, firstly, you want to find out who you're getting in bed with. So what you want to do is look into their background, their education, their professional experience, references, prior company ownership, if they're licensed, any issues with that. You want to investigate all those scenarios. You also, I would have a real deep conversation with you, Chris, and I would find out every nook and cranny regarding what your goals are here and what your expectations are. And after that deep conversation, I would speak to the other side of the transaction, and I would ask them the very similar questions, because I'd want to find out where their head is, what they want. You guys, this complicated concept of white label maybe be thrown out, but you guys actually have very different understandings of what that word means. So, I mean, for example, I know sometimes I can be a little wordy. Oh, well, and my language may get misinterpreted or misunderstood or not understood at all. So you really want to, in simple language, have a clear understanding of what the goals are and what the expectations are of getting to those particular goals. So, the start again is just, before you sleep with them, look at their Tinder profile.
Yeah.
Like try to figure out who they are. Linking it to life. Do a social media, and I know this may sound a little weird, but do a social media search. See what their social media looks like. Look at their LinkedIn, their Instagram, their TikTok, their Facebook, whatever it may be. Learn a lot about them. Do a search, just a general Google search on their name. Do a background search. So, you don't want to get business herpes, So like you want to make sure that everything's nice and clean when you ultimately get into bed together as a business partner. And of course, then again, the next step is making everything formal. The next step is writing everything down and getting it signed off on. And that you need to be as detailed as possible. Well, actually, let me back up. Sometimes deals need to die. Unfortunately, my goal as a transactional attorney is, so long as it benefits my client, get the deal done if you can. So sometimes you have to compromise. But sometimes deals die because the parties are so fundamentally apart in their ideas that what he wants and what you want can never happen because you're just too far apart. And again, as far as the making that determination, that takes honest, sit-down conversation. A lot of times, to be honest, I've experienced that people are engaged in transactions and they'll use language that they don't really know what that language means. There's this expression, terms of art, which all it really means is that within a particular industry, be it legal, be it engineering, be it whatever, these specific words mean these specific things. And terms of art don't necessarily line up with what just a normal English language understanding would be. So you need to make sure in simple language that everyone knows what's going on.
Yeah. And in a case like this, you would be able to be hired find those red flags and figure out, hey, like this person's legit, this person is not legit, or that would be on me to do the research?
My firm, either some aspects of it I would conduct individually, other aspects we would bring experts on or investigators on to undertake.
Yeah.
It all depends upon how much peace of mind the client wants. If you're buying into a company, you need full financials. You need full details. I had this one transaction, one matter that's in litigation where someone ended up getting sued based upon a bill of sale. They entered into agreement for a sale of a company and its assets, and the bill of sale was left blank. How could you not actually, the company
Yeah.
and its assets? Okay, the bill of sale, what are its assets? And the exhibit A that was supposed to contain those assets didn't contain all of them either. And it was just, it was that was the complete opposite of how it should be done.
Sure. And it sounds like that person did it on their own. They didn't hire legal.
Yeah, the two parties did it on their own.
Makes sense.
It sort of looked like they just pulled forms off of Google.
Sure.
Yeah.
So the reason I brought up the white label example or what have you is because we're talking about broken promises and broken deals. And we started this episode talking about the pardon and how President Biden had promised he was not going to pardon his son. Then they pardoned him before they even did a full investigation and he was convicted. And we're like, well, that's crazy. But we can't do anything about that, which is so interesting. But we do have things in place to make sure that, we're protecting ourselves when, well, like you mentioned, we get into bed with people in business. So as we start to end this episode, Gavin, do you have any examples of broken deals that you saw take place in your experience, and then really kind of dissecting that and figuring out how that could have been mitigated?
I saw there was this transaction regarding real property, and the parties, the buyer still wanted to buy the property, but the seller was in default, and the seller wasn't curing the default. So rather than sue for specific performance, the buyer said, fine, whatever, I'll just take my deposit back,
Mm-hmm.
So they drafted up that, and they do have like standard releases that are forms used by the Florida Association of Realtors and such, like MLS or whatever the entity is that has those forms. And some brokerages have their own internal forms, but those aren't heavy on detail. So, for example, in this instance, there was by the seller, there was supposed to be a full release of all obligations that the buyer had to the seller. So a mutual release. Both sides were supposed to release each other from everything. The problem with that is that what ended up happening is out of the gate, and I don't want to say the amounts were owed, but one of the amounts that the seller claimed was owed by the buyer to the seller, which was outside of the monies in the contract, the seller refused to release that and said, "Owe me that money," almost out of the gate. So, the only reason the buyer still wanted to buy the property, and this actually case is a few years old, so it's a little bit from memory, but the only reason the buyer wanted to release it is because he didn't want to have to deal with any problems anymore, And also by executing this release, the buyer effectively freed up the property. So if the seller wanted to, the seller could sell it to someone else. And, this was during a period in time when property values, I mean, it seems since 2008, they've just been skyrocketing.
Yeah.
But when property values were going up. So the release and the comfort and everything like that was the expectation. Oh, and that's right. I forgot this point. Because there was a dispute as to the full release, that could impact the agreement as a whole, but also potentially the release of the funds that were held in escrow. So the buyer's not getting what he wants. The seller's got a situation where there's no lien on the property, and you have some significant problem.
Sure.
One of the things that was done properly, and thankfully, is that it was very clear from the inception that there was no intent on the part of the seller to fully comply with the release. So delay because he immediately made it clear that he did not intend to release that particular item that was not directly related to the contract. So it is pretty good evidence of intent, though certainly not definitive, but pretty good, where one of the things that you're contracting for out of the gate after everything's signed off on the other side says, yeah, I'm not doing that. There's a different, like, if it's just a standard breach, that's one scenario. But fraud is when, and let me, this is a very important point. If you enter into a contract and you just don't do what you're supposed to do, but when you sign that contract, you meant to, you just have a simple breach of contract.
Mm-hmm.
But when prior to signing that contract, you never intended to honor it, well, then you have fraud in the inducement, which can allow you to rescind the prior agreement, et cetera, et cetera. And rescind just means set it aside, like it never existed, which in this case would have put the buyer back in a position the buyer wanted to be before he entered into the release and everything of that nature. So timing is very important. Do not sit on your hands in these matters. If there are conditions that need to be satisfied or promises made, before the agreement, you want to be specific to prevent it. But after the agreement, you want to make sure that, all right, so, here's the situations. I owe you nothing, right? I don't owe you for this. This. So if you didn't do it in the front end, at least do it in the back end as soon as possible,
Yeah.
Hopefully, if you have good counsel, you're not going to have to worry about fixing it. But in any context, acting quickly is very important. For example, I believe for specific performance is when you sue someone to make them do what they said they would do. I believe it's either a 1 or 2 years you have to bring suit from when they refuse to do it. So timing is very important. Like on most written contracts are 5 years, for example, so you have much more time.
Yeah. Yeah, man. There's so many possible ways, obviously, that these deals can fall through. What's so interesting about our conversation today is that we were talking about things where people literally do not intend to hold up their end of the deal at all. Mm-hmm. And it's going to break through. And so I think some of the things that you shared today in terms of specificity and due diligence and making sure that, you're looking for those red flags, you're making sure the person is legit, you're making sure that you're super specific in the actual agreements, and then, timing, it being a huge, huge piece of the puzzle here, are really helpful for people to consider before they, as you say, get into bed with people in business.
Absolutely.
So yeah, man. Well, cool. So that's it for today's episode, guys. Thanks for joining the podcast, Life, Legal, and Headlines. And look, make sure you subscribe to the show, comment below, let us know what you want to hear more of as it relates to all the topics that we are, currently going through. Hey, that was really good, but let's talk about the gray label, for instance, and what's the difference, etc. All the things, hit us in the comments below, and we'll be sure to consider putting episodes together. So, Gavin, thanks for being with us today, man.
Pleasure as always, Chris. Thank you, man.
All right, man. We'll see you guys next episode. Bye.